I'm now looking at the picture of myself and I kind of look like Severus Snape with the black background, which kind of makes me happy. So maybe you shouldn't pull up the kitten picture after all. Okay. Should be good. Okay. All right, good morning. As I said, and then welcome to the YouTubers if you didn't hear me before because that little cord wasn't plugged in. Susan Eisenman, I'm from the Attorney General's office, and I'm just hopefully going to warm you up for a really good, enriching day of learning about the Government Records Access and Management Act. So for whoever asked the question, what is GRAMA? That is your answer. You can check that box off on your bingo card. And I'm going to kind of tell you from my 20 years experience in government, 10 things that I think are critical for you to know about GRAMA. And I see many people who I've trained before here, so hopefully I won't bore you. The first, and I think the most important thing you need to know about GRAMA, particularly for you new people, is that GRAMA is hard. GRAMA is hard. Very little in GRAMA is black and white. And GRAMA requires you to actually analyze data and think about a variety of issues, some of which are legal or quasi-legal issues. And I can't emphasize this enough. I know, because I've worked with so many people like you over 20 years, that what GRAMA records officers and people who respond to GRAMA requests crave more than anything is something black and white. If it is this, then don't give it out. And I'm sorry to say, and I just want to remind you, you have to come back after the break, but I'm sorry to say that that is just simply very rarely the case in GRAMA. Very little about GRAMA is black and white. For almost every rule in GRAMA, there's a but. And we'll be talking about a lot of buts today. And in GRAMA and the science of records management has just gotten so much more complex because of all the electronic data and media that has taken over the world, really in a very relatively short time. And I think when GRAMA was written, it was written in a paper world, and now we live in this electronic world. And I just want to suggest to you that really one of the hardest parts about GRAMA, and we're going to touch upon this a lot this morning, is the ease of creating records now. You know, back in the old days, you actually picked up a phone, and for you really young people, it used to be attached to the wall. And you would talk to people. And conversations are not records under GRAMA. And so those kind of things would just happen, and they wouldn't be part of a GRAMA request. Now, I would like to suggest, and probably some of you are doing it right now, people converse through electronic medium, which creates a record, right? You're texting, you're tweeting, you're doing the IMing, you're emailing, and that those conversations, which used to be not records, are now records. And people, particularly the people who will frustrate you as records officers, don't realize that conversation is now creating records. So the first thing you need to know about GRAMA is it's hard, and conferences like this help make it easier, so go to them frequently. To answer some of your questions, what is GRAMA? We already have that, the Government Records Access and Management Act. I'm mostly going to be talking about records requests, but remember there's a whole other part of GRAMA, which is the classification and retention of records, right? How long you keep them and how you classify them. There's also, for those who work, anyone work with federal records? Just a couple hands. FOIA is another acronym you hear all the time. That's the Federal Freedom of Information Act. A lot of times you'll get requests that say FOIA when they really mean GRAMA, but that's just another acronym to know. Another question you asked is it best to have more than one employee receive GRAMA requests so that if one is unavailable to reply? And to that, my personal opinion is yes, for a couple of reasons. You know, the first reason being GRAMA is hard. So it's good to have at least two people trained on GRAMA that you can bounce ideas back and forth of. The other reason why is because the time limits in GRAMA are very quick. In most cases, you have 10 days to reply, 10 business days, unless an expedited request is sent, in which case you have 5. Now, your first but of the day is there's a number of exceptions for extraordinary circumstances where you can go more than 10 days. But in general, think to yourself, 10 or 5 days to respond. And I think there might be a bingo thing on that, so you might want to check. So yes, it's good to have definitely more than one person trained on GRAMA. So GRAMA is hard, so why should you do it? GRAMA is about transparency, and transparency is good for government. This is a hard one, particularly for the people who work in human services fields and law enforcement fields. Sometimes it's really hard to think about that, and you will have people who create records who don't agree with this principle. But let me try to convince you. Why is transparency good for government? Transparency increases confidence in government. And I mean that sincerely, and any people who read the paper, or who are reading the paper right now, you'll see that when there's no confidence in government, it really creates a lot of negative energy. And I want to suggest to you that kind of negative energy can take a lot of time away from the good work that your government agencies are doing for the people of the state of Utah. So transparency increases confidence in government. It helps uncover and root out wrongdoing when it occurs, which we're fortunate in Utah, it's pretty rare. I like to remind myself and my subordinates that my salary is paid for by the taxpayers, and so is everyone in my office, and taxpayers deserve to know how their money is spent. And also transparency is the law. But there's a but. And I think it's important to read the legislative intent. And some days when you're feeling down, maybe you should open up the statute book and read this, right? The legislature, read the law when you're feeling down. The legislature recognizes two constitutional rights, right? The public's right of access to information concerning the conduct of the public's business, and the right of privacy in relation to personal data gathered by government entities. And it is the intent of the legislature in GRAMA to promote the public's right of easy and reasonable access to unrestricted public records, to prevent abuse of confidentiality by government entities by permitting confidential treatment of records only in limited circumstances, and to favor public access when countervailing interests are of equal weight. You can tell that was written by lawyers, right? All those big words. But the general focus of GRAMA, the legislative intent, and here you are, you're upholding the law by doing your job, is to promote the public's right of easy and reasonable access, and to prevent abuse of confidentiality, and to favor access when the interests are equal. But remember that there's also a right of privacy recognized in GRAMA, and that is mostly in relation to personal data gathered by governmental entities. We're going to get back to that, I think, at like number 4 or 5. Okay, so transparency is good. And you will have to remind the people who create the records that you give out. I like to do this with a smile, right? Because most of the time people come to you and they're going to say, we really don't want to give that out. And you have to remind yourself and them that transparency is good for government. Okay, first nuts and bolts thing you need to know, and this is important. GRAMA governs records. Knowing what is and is not a record is critical, and that's in section 103 of the statute. One of the things that my clients find most shocking is the following. A record means a book, letter, document, paper, map, plan, electronic data, documentary material, regardless of physical form. So that's, the big, vast world of records. But a record is any of those things that is prepared by the governmental entity. That's not too shocking, right? You figure if you create a record, it's a government record. But a record also covers things that are owned, received, or retained by a governmental entity. And I really want you to pay attention to those words. Received or retained by a governmental entity. I think there's a big misperception among people who do what you do, that if you didn't create the record, it's not a record. If a private person submits something to you, it's not a record. And I want to suggest to you that, in fact, it is. If you receive it, own it, or retain it, it is a government record. And then there's this kind of a second part of what is a government record, and that's where the information is reproducible by photocopy or other mechanical or electronic means. There's some really interesting, I think, philosophical debate about what is and is not reproducible related to electronics and metadata. I'm probably not the best person to talk about that since I'm using a notebook to talk to you, but there are interesting things there. But just know if you can reproduce the record and it's prepared, owned, received, or retained, then it is a record under GRAMA, which means you have to consider it in your records analysis. So when you think about a text message, is that reproducible? You know, you can take a screenshot of it, you can type out what it says. I would say yes. I mean, there might be others who would look at the zeros and ones that go with that and say no, but that's how you should be thinking. Now, there's a but here. There are 15 categories of non-records, and you need to know what those are. Some of the highlights here include personal notes, and there's a big, fascinating legal debate about what is and is not a personal note. Copyrighted material where the government doesn't own the copyright, proprietary software. Does anyone work with judges? Anyone from the courts here today? There's some exceptions for the courts. Junk mail, books that are contained in libraries. And an important one for you all is private phone numbers of government employees are not records if there's a public number where that employee can be reached. So hopefully that will give some of you comfort already. So note that just because it isn't a record doesn't mean your agency can't give it out. You know, there might be a personal note that you would want to give out, but it is not a record governed by GRAMA because it's in that categorical exceptions. So somebody in this room asked, what is a record and a non-record? Hopefully that question is now answered. And then another question that you asked was, how should record requests be submitted? GRAMA requires record requests to be submitted in writing with reasonable specificity and with the contact info for the requester. Those are the basic three things you need. Does it have to be on a form? No, it just has to be in writing. I would like to suggest to you, though, because I have in the past represented the Division of Services for People with Disabilities, that even though GRAMA doesn't require it, if there is someone who cannot, due to a disability, submit a record request in writing, perhaps you should help them. But that's just a little plug for thinking of others, not required by the law. Okay, the next two things I'm going to go through pretty quickly. GRAMA, so now you know what a record is, right? Anything, you know, prepared, owned, received, or retained. When GRAMA looks at the content of the record, not the form, and I hope other people are going to hit on this today. So I think that's another hard thing for people to understand, and it's another one of those GRAMA is hard things where there's not an easy rule, right? I think people would love to say all emails are classified as private. Now, if we could get, Paul's talking about legislation, so you should be thinking about, can we get a law passed that says all emails are classified as private? The answer to that is probably not, but that would be a wrong way of thinking about GRAMA anyway, right? Because GRAMA looks at the content of the record, not the form. Email is the form of the record. It's the content of the record that determines how it's classified. And by classified, I mean whether it's public, private, protected, or controlled. So don't think about it as all emails are X. You have to think about it as all records about the investigation of Sally Smith, right? Then you're thinking of what is the content of the record, not the form. This is one of the things that makes GRAMA really hard, but it's important. Also, and I think I already touched on this one, records under GRAMA are presumptively public, and when the interests are equal, the public's interests will prevail. So, the next two things are important. The second one is probably the most important thing I want to impart to you today. There are lots of sections in GRAMA that protect the records of clients of the government and persons who interact with government agencies. And those are the sections in GRAMA that talk about records being private, controlled, or protected. Now, what I'm about to say is a very big generalization, and I don't want it to substitute for good analysis. But in general, think of it this way. Private records are those where your client has a privacy interest. Things like records about human services interactions, records about, you know, things your clients tell you, and that kind of thing. Those are essentially private records. Controlled records are about medical records, primarily about a particular subset of medical records where giving them out even to the client of the record is not industry standard. And things like, and those of you who don't work in the mental health industry don't have to worry about this really, but psychological evaluations are kind of the big example of a medical record that is so private that it's not even given out to the person who's the subject of it. And it's a pretty small subset. Protected records has about 45 classifications of what I would say are the sorts of things that government agencies create but that you wouldn't want the public to know. And it's really important that you go through that list of 43 and think of the ones that apply to your agency. They're everything from like security measures, where bombs are located, this type of stuff that it's not private, it's not about a client, but you certainly wouldn't want the public to know. Attorney-client privilege is under this section. There are a whole bunch of categories of records there, and you need to know what those are. So all of those things protect records of clients and persons who interact with government agencies and really sensitive government information. And now, for the most important thing I'm going to tell you today. I'm giving everyone, those of you on YouTube, the most important thing I'm going to tell you today. Okay. There is almost nothing in GRAMA that protects a government employee from a record simply because that record is embarrassing. Let me say that again. There is nothing in GRAMA that protects a government employee from just because the record is embarrassing. If I had $1 for every time a government employee wanted me to not give out a record just because it is embarrassing, I would be very rich. There is almost nothing in GRAMA that protects a government employee from the embarrassing things they put in writing. And I'm sorry for you, because that is a message that you are going to have to tell the people who create the records that you administer a lot. You can say that I told you to say it. The caveat here is that email will be the death of us all, right? I mean, and this goes back to the whole notion that emails and tweets and IMs and texts have replaced conversation. So for some reason, government employees feel just fine saying in these government records the stuff they used to say on the phone. And it's everywhere. And, raise your hand if you haven't sent an embarrassing email, then we'll know who the liars in the room are. And I will give you one personal example, just one. And remember, I'm the records person. I'm teaching you. I should know better, but here's one from the annals of Susan Eisenman's embarrassing records that in fact went to the Deseret News. So I'm the division chief of a large division with a whole bunch of stuff going on. And obviously I don't do all of it. I have other people who do a lot of it. And one of the things that came up was a mining issue in rural Utah. And my boss said to me, could you please go to this meeting? It's about a mining issue. It's kind of hot and I can't make it. So I said, sure, I hope I won't frack it up. And I didn't even put a smiley face emoticon, right? And 2 weeks later, that email was yes in the hands of the Deseret News, because in fact it was a hot issue. And right, was there anything about that record that dealt with our private clients' records? No. Any protected medical records there? No, other than I'm really stupid to put that in writing. And 3, any protected government secrets there? No, just me looking like a dummy. So the thing you will want the most in this job, and the things the people you work with want most in this job, is something in GRAMA that protects them from the embarrassing emails and things they put in writing that they wish they didn't. And I'm here to tell you today, it does not exist. Good luck. Okay. Now, this is another important thing. There are very few ways, and let me start out by saying, I'm sorry, this is true. There are very few ways to protect government agencies from what I like to call difficult requesters. Please raise your hand if you have had experience with a difficult requester. I'm so glad to see that Rosemary raised her hand, because I think of her job as primarily dealing with difficult requesters, but she probably views her job as, helping people and getting to solutions, and that's why she's so great at what she does. Really, because of all the things I've said before, it's about transparency, it's about the public's right to know. So there are very few ways to protect government agencies from difficult requesters, and I have a lot of sympathy for you, because we all know that there can be requesters who can take up a lot of time and effort because they are really, really energetic and zealous about getting your records. I'd like to suggest to you a few things to help. See, I do have a few helpful things to say here today. First of all, as I said earlier, a record request must state with a reasonable specificity the record or record series requested. That's one of the tools in your toolbox that you can use to protect the government agency from difficult requesters. And a lot of times, requesters ask for, every document ever created by the Department of Health, right? I would like to suggest that you could try saying that that is not reasonably specific. It doesn't deal with a record or a record series, because all health records are tons of record series. Sometimes they, start there. Start saying, is this request reasonably specific so that I know where to go to look? Extraordinary circumstances, which is the part of GRAMA that gives you more than 10 days to respond. A voluminous request is one of the things. Requires legal analysis is another. Look at those. Sometimes those circumstances can help, at least give you more time to respond. Another important thing to know is that you don't have to respond to duplicative requests. So if the same person is asking you for the same records, but just a slightly different way, that's something you can use. If this was a question that was asked, if the information is already public and online, it's still a GRAMA request for the record, but you can just direct them to where it is in the public. You don't have to reproduce the public data for them. You don't have to create a record in response to a request for records. So if they're asking for some kind of aggregate chart or form that you don't normally create in your course of business, you're not required to provide it. I want to give a little but here, which is you can provide it if you want to. And there are many cases where people ask for aggregate data where aggregating it is a great idea for the government agency. And you might consider and talk to whoever manages the data, whether that's a good idea, but you're not required to create a record in response to a request under GRAMA. And another thing that can help is knowing what's a request for records as opposed to a request for something else. A lot of times our difficult requesters aren't really seeking records, they're seeking like vindication or the government agency's head's resignation or a meeting with the governor or, why don't you tell me why you're doing these unconstitutional, terrible things to me? And I'm not trying to diminish at all their feelings in that regard, but those are not requests for records, right? Those are requests for something else. And then you have to talk to your agencies about how you want to respond to those, but those are not requests for records, so that's something. And fees. Fees are, you can charge fees. You're encouraged to waive fees in a number of circumstances, and you should know what those are. But government agencies, at least now, do have the ability to charge fees, and you should look at when that is a reasonable thing to do to handle difficult requesters, especially those that repeatedly request voluminous information. The final thing that I want to suggest can help you, but can sometimes not, with difficult requesters is communicating directly with the requester. And I think there's a newspaper person coming later today who I think will talk about communication, so hopefully you'll hit on this a little bit more. A lot of times when you call a request, if you just talking to the requester, and Rosemary's probably the poster person for this, if you just talk to the requester, you can narrow the request and make it reasonable. Okay, I only have 5 minutes left, and I have 2 things really important to tell you, but I'm on 8, so I'm doing pretty good. So number 9 is a records classification is only the beginning. And I saw some questions about if records have a secondary classification, what does that mean? And I want to suggest to you that a 2008 Utah Supreme Court case, the Deseret News case, changed everything. Because that case said that the classification, which is that public, private, protected, or controlled, name, label that you put on records and record series is only the beginning. And that GRAMA requires, it's hard and you have to think part again, GRAMA requires you to conduct a conscientious and neutral assessment of the report. And so there's a second step. A classification is a prediction of what the record would be, but then you actually have to look at the request. You have to balance the competing interests between the requester's need for the record and the government's privacy interests, and you have to do that in every case. I'd like to suggest to you, and this is sort of my last point, but I do want to talk about subpoenas really quickly in my last 2 minutes. Deseret News made it clear that GRAMA is hard. Right? You can't just say, oh, look, on archives it says that record's protected, so denied. You actually, the classification is a predictor, and then you have to weigh the government and the public interests. And I want you to know you shouldn't do that alone and in a vacuum. You should know who your lawyer is, who knows GRAMA and can help you with those kind of questions. You should know the resources that are available to you through the Records Center and Archives. Rosemary is a great one. You should know that there are people at Archives who help me all the time with classification and retention questions. So and you should have more than one person trained up in GRAMA to help you. Electronic media has made it so much harder too. So know that GRAMA is hard and seek help when you need it. Finally, and Paul said I could take a couple of extra minutes because legislation was pretty low this year, but a couple of you asked about the differences between discovery and GRAMA requests. Discovery relates to getting records in conjunction with an active lawsuit. Could be a state lawsuit, a federal lawsuit, an administrative hearing. And GRAMA requests, or just anyone can ask for records, right? So as of now, GRAMA requests and discoveries are pretty much two separate processes, but the most important thing I want you to know about that is if you get something that looks like there's a court case, and here are the words you need to look for, right? Complaint. Complaint with jury demand. Notice of claim. Subpoena or subpoena ducis tecum, right? Those are all lawyer buzzwords that says, oh boy, there's a lawsuit pending. You need to talk to the lawyer for your agency and get some clarity in how to respond. I think that's the most important thing I can say in just a short period of time. There are some sections of GRAMA that talk about discovery, particularly related to subpoenas not being equivalent to a GRAMA request, and you need a court order, a specific court order under GRAMA to get private, protected, and controlled records as opposed to using a subpoena. But you need a lawyer to help you there. So subpoena, notice of claim, complaint, order to show cause, that's a really important one because that means someone's going to jail or getting fined. Those are the kinds of things that you need to immediately tell a lawyer. Also know that time is of the essence on those. I'm almost out of time, but I thought I would just end with going through in my mind what I do to answer the question, what exactly do I need to be doing as a records officer? I'd like to suggest that as you learn today, create a framework or a thinking tree for yourself. This is mine. Is this a GRAMA request? That's the first thing I ask myself. Is it in writing? Is it reasonably specific? And is it asking for records as opposed to something else? Does my agency prepare, maintain, receive, or retain these records? If not, and you know who does, you can refer them to another agency. And if not, you're not. You can say, we don't have the records and deny. If the answer to those questions are yes, you have to actually gather the records, find who has them and where they are, and that in itself is its own difficult thing in our electronic world. And then you have to review the records to determine if they're responsive, if they're public, private, protected, or controlled, or exempt. And then for non-public information, if it's private or protected or controlled, determine if this requester is entitled to it. And you have to balance those competing interests. If the records are exempt, which is primarily in my world, HIPAA and FERPA, then you have to determine whether those laws control and what to do about it. Then you determine what the requester is entitled to get, and you give it to them. And whatever you don't give to them, you send them a letter, a denial letter, telling them what it is. And yes, someone asked, can you create a boilerplate for that? You can, but you have to identify the records denied pretty reasonably specifically. And finally, you have to do all of this in 10 days, unless they've asked for an expedited response, in which case you have to do it in 5. So, GRAMA's hard. Learn a lot today and seek help between yourselves and from archives. Thank you.